which is on Article 23. So only one article on which we are going to discuss, and that which I have given origin, development, present status of Article 23 of the Constitution. How far we have achieved abolition of modern day slavery. So basically we looked into Article 23, where we stand for, what we have achieved, how we can be able to achieve what's mandated by Article 23 of the Constitution. So this is not the article which very frequently referred to. So we are more concerned with Article 21, right to life, or other aspects where we have a lots of discussions. But I really thought Article 23 because it is one of the issues or one of the mandates which it has given is to abolish slavery from India. And how many of you still feel that this slavery in different form still exists in India? Anyone has any idea where we stand? Numbers, etc. If you have to see the statistics of number of slaves, any idea where we will find those statistics? Global number of slave or trafficked people. So trafficking we call modern day slavery. Article 23 use traffic word. Where you can get those statistics if you read it as a student of law or a student of social science? If you have to look some statistics, you have to see or analyze where we stand, how much people are still enslaved, where you can get it. Any idea? Okay. There are two reports, and for which we have to understand the two reports. We'll directly look into in details. One report which started publishing from the year 2000, we call it TIP, Trafficking in Persons Report. It's published by Department of State USA, and now UNODC has taken it up and it's published by UNODC. This report when it started in the year 2000, it was basically there are two things which come simultaneously same time. One was under the Organized Crime Conventions, there is a protocol on trafficking. At the same time in USA there is a law called TVPA, Trafficking Victim Protections Act. That legislation has mandated US government to assess the state responses on trafficking throughout the world. And trafficking is called modern day slavery. So mandate of the TVPA, under which the government of USA basically they started publishing the annual report. We will look into this report a little later. Second thing from where we can get the statistics. If you have to see where we stand as India, where other countries stand, where we stand in comparison to other, or as a region in Asia we stand, this is the report which always we look for. The second report which started publishing again yearly from 2011 or 12 onwards. It's published from the Australia, and this is an organization called Walk Free Foundation, which again work for the anti-slavery movement throughout the world. Walk Free Foundation started publishing one report, yearly report, and the report name is Slavery Index. So in Slavery Index, they try to create index of the each countries of the world where they stand. Okay, let me come to Constitution, then gradually we look into where we are there in respect of the slavery or trafficking, the words we have used. Remember, in the constitutions we got Article 23 presently. I just before going to the let me see the historical part which let's talk about. We do discuss several things, but we don't discuss Article 23 to that much. But we are really one of the worst sufferers of the modern day slavery. So this present Article 23 will be seen. Even it was produced in the draft format, so draft constitution. The drafting committee has submitted a draft constitution in 21st February 1948 to the President of the Constituent Assembly. in draft constitutions, the number was 17. So for the article which is presently is Article 23. And this draft constitution, when they placed Article 17, the wording was Clause 1: traffic in human being and beggar and other forms of forced labor are prohibited, and any contraventions of this provision shall be an offence punishable according to law. So first part categorically take care of any kinds of trafficking of human being or beggar is completely prohibited. Second clause wanted to take care of where the government can mandate as a matters of punishment sometimes compulsory labor. So in a jail, now there is no jail, it's all correctional home. So in the jail premises, in modern term correctional homes, there is a concept of compulsory labor. So in that regard, the clause 2 says, nothing in this article shall prevent from state from imposing compulsory service for public purpose. In imposing such service, the state shall not make any discrimination on the ground of race, religion, caste or class. So clause 2 just wanted to give an exception that there could be compulsory labor by some prisoners, etc. When this bill placed in the by the drafting committee in the Constituent Assembly, now when we use the word slavery, so some places use modern day slavery, some places use that times or still exists in many places concept of devdasi, bonded labor with different nomenclatures. Even sometimes slavery is for sexual exploitation, for prostitution. But when in 1948 when it was placed, that point of time, the slavery was, though there are international conventions for abolition of slavery, etc., there is a UDHR when it came into existence. Our UDHR categorically says everyone has born free, that means no one can be enslaved. So category mandates are there. That mandate again goes into in ICCPR, etc., where the categorically says that there cannot be anyone slave, everyone is born free. So in most places that point of time, because the slavery word is commonly used. So accordingly, there were multiple suggestions given in the drafting process of the Article 23. What was those suggestions was given? So there were several amendments suggested by members of the Constituent Assembly. For instance, Qazi Sayyid Karimuddin, he suggested that in Clause 1 of Draft Article 17, and section was, neither slavery nor involuntary servitude such as beggar, except as a punishment for crimes shall exist within the Union Territory. So his suggestion was categorically to include the word slavery in the Article 23 of the then Article 17 draft article. There is another person, Damodar suggested that we must include the word servitude and serfdom in Article 17. Sri K.T. Shah, he was also member of the Constituent Assembly, and he suggested that in Article 17 we must include dedications in the name of religions to the Devdasis or other forms of enslavement. So there he also makes suggestions that in Article 73 where we have used the word only trafficking, the Devdasi concept etc. should also be included categorically. K.T. Shah also makes some other suggestions, and where it says this his comment was at that point of time. The statement of K.T. Shah in Constituent Assembly is important and shows the wide varied dignity of the womanhood. K.T. Shah's statement was there. He said that traffic in human being is not confined only to what was known as slavery in recent time. It happens, and perhaps it has happened on a much larger scale, that innocent members of this house may be aware is what is known as white slave trade. When we use the white slave trade, remember in international law, we see the modern legislation which has come in human rights jurisprudence and international law. It's all started with the UDHR and post judicial, we say first instrument is judicial, universal declaration of human rights. Thereafter we have ICCPR, international covenant and civil and political rights. ICSCR, international covenant, economic, social, cultural rights. But much before this UDHR or ICSCR, ICSCR, which comes in UDHR 48, ICSCR 66, etc. Much before that, even from 1923 onwards, 1923 to 1944, there were 4 agreements, international agreements signed specifically for white slavery or trafficking that point of time. So when we use the word this trafficking or anti-trafficking or anti-slavery movement, it is even before the UN system, even the League of Nations has developed much agreement by which the countries who are the members, they try to abolish this trafficking. So we have a 1923, then 27 or 28, then 33, 34. So there are 4 agreements which came into existence. And how many of you this heard this act called ITPA, Immoral Trafficking Act? ITPA is a legislation which addresses basically sex trafficking or trafficking for the purpose of sexual exploitations. ITPA is based on convention which adopted in 1949 for trafficking persons. Now this 1949 conventions, if you see, it is basically culmination or accumulations of earlier 4 agreements which was signed between 1923 to 1934, and categorically in paper is referred to all these 4 conventions. So when we say anti-slavery movement or trafficking movement, it's not something even start with the UDHR. It goes much beyond. Even from 1923 onwards, the effort at the international level has been taken to combat this. So we can see those reflections in when the Constituent Assembly debate taking place. In those debates also, there are members who specifically refer to. So KT specifically refer to what is known as a white slave traffic. So white slave traffic has been used in 1923 agreement, 1927 agreement, both the agreements. The buying and selling of young women for export or import from one set of countries to another, and their permanent enslavement or servitude to an owner or proprietor established commercialized buyers probably for life. So there was that point of time in many places in the world where girls are trafficked from one part and brought to the part. Initially when 1923 started with white slavery, the concept was they were concerned that people from a particular background are exported to other countries for the purpose of prostitution. So they started with general specific prostitution and then gradually developed to all kinds of trafficking for the purpose of prostitution. KT's emphasis was on Devdasi, his emphasis was on white slavery. And then he went further and he says that apart from including this thing in clause 1, the clause 2 of article 3, which we see, clause 2 of article 3 says, nothing in this article shall prevent the state from imposing compulsory service for public purpose. In imposing such services, the state shall not make any discrimination on the ground. Here in on the ground, it is suggested that you should add only word. So only on the ground. Now, so there are many suggestions, including this one suggestion given by the KT Shah, which says the only word should be added in clause 2. So his idea was that only on the ground of race, caste, religion, etc. On that ground, you cannot force someone to go for compulsory labor work. It could be something more. So only on the ground of particular caste, we cannot ask them to do it. So that was the suggestion given by the KT Shah. So KT Shah says only. He expressed his conviction that this small amendment is brought in, it will be accepted by the draftsman. In that way, we find many suggestions also come. Like for instance, says Raj Bahadur was a member of the Constituent Assembly, and he said, acts for prevention of immoral trafficking in women do exist already in this country, but their operation is not effective, and even if legal flaws are amended, this can only become really effective when man's mind changes towards this problem, whereby sections of women are at the mercy of exploiters. So in that way, even at the stage of Constituent Assembly, we see there was a wide knowledge or information about the anti-slavery categories in which people are made slave that point of time. Now, the issue comes whether we are going to implement all these amendments in Article 23. Present Article 23, D then Article 17 of the Constitution. When D then Article 17 of the Constitution came into existence, after all these deliberations, then the father of our Constitution, B.R. Ambedkar, was asked his opinion what to do, whether we include, because the issue comes to talk directly combating sex trafficking, issue comes to include what slavery explicitly, issue comes to include the principle of Devdasi, issue comes to include bonded labor. So there are many varieties of the manner in which a person is trafficked. All those varieties have been brought in by the different member in the Constituent Assembly. So what amendment we can go for? So if you go to the Constituent Assembly debate, Dr. Ambedkar is trying to settle the issue that what can be included, what could not be included. I am just quoting his statement. Dr. Ambedkar says on all these statements, he said, Mr. Vice President, I should like to state at the outset what amendment I am prepared to accept and what I am afraid. I cannot accept of the amendment that have been moved. The only amendment which I am prepared to accept is the amendment by Professor K.T. Shah, which introduces the word only in clause 2 of Article 17 after the word discriminations on the ground. So while there was a 11-12 suggestion which made by the different members, Ambedkar was of the view that the word trafficking is broad enough to include everything. In clause 2, where the K.T. Shah says that only should be added before discriminations on the ground of religion, caste, etc., that can be added. He again says, I am afraid I cannot accept with regard to the amendment which I said, I cannot accept one by Professor K.T. Shah introducing the word Devdasis. Now I understand that this argument for including Devdasi has been replied by other members of the House who have taken part in this debate, and I do not think that any useful purpose will serve by my adding anything in this argument that have already been urged. So Dr. Ambedkar settled the issue. They say that other members have put forward their views, whether we should include the other words there or not. Devdasi, trafficking, white slave, trafficking for sexual exploitations, bonded labor, other customs of the bonded labor in some part, all the discussion comes in the Constituent Assembly. So he says we don't require to include all of them because other member has replied. What he meant was, one of the members, Shri T.T. Krishnachari, who was a member, he during his deliberations has responded to some of the other members. And what his response was said during deliberation that, there are many places in the country where we have certain specific laws which can take care of the social evils. For instance, he referred to for Devdasi. Even that point of time, there was a special law in Madras which abolished Devdasi systems and asked of punishment. So, what his view was that these different evil, like for sexual exploitations, Devdasis, bonded labor, all those things which are, one, they are included in the trafficking word. Two, these smaller evil can be addressed or can be taken care of or can be combated by the different statutes which need immediate address. When we including something in fundamental right, we are not including something for next 2, 3, 4 years, but we are including for all along the existence of this country. So we don't want Devdasi system to continue for longer time or other system to continue for longer time. Let this be settled by the other legislations. Fundamental right things will keep which can serve the longer purpose. This idea was Devdasi can abolish in next 3, 4, 5 years. Other thing we can abolish in next 3, 5, 4 years. That was his idea. He also had to quote him what he said in the Constituent Assembly. T.T. Krishnachari said, we are trying to root it out, and by putting it in the fundamental right, it will hasten legislations to wipe out a bill of that kind, as it will then become an obligation of the state. I would only mention to the House that let us not seek to enlarge the scope of this article by putting in evils which can be wiped out by legislation. So his view was that all the social evils which are there, we should not put in Article 23 to Article 17, then Article 17 to expand it further. These all evils can be taken care of by different legislation with that point of time the legislation will make. I would mention to the House that let us not seek to enlarge the scope, etc. By legislation on which public opinion is sufficiently mobilized, but only import into it such considerations against which vested interests might conceivably taken a firm stand. Sir, I support the article that is being considered by the House. So, what happened was, because of this Brahmachari statement, and which was supported by Ambedkar, in Article 17 has not seen any amendment except only inclusion of word only in the clause 2, which is talking about the compulsory labor. So that's what the Article 23 what we stand for today. So what we see Article 23 today at this time, it's the same article which was placed in as Article 17 in the Constituent Assembly. Now, if that's so, Article 23, as it's talking about trafficking, its mandate is for abolitions of all modern day slavery. So, trafficking in any form should include all other kinds of trafficking, all other kinds of modern day slavery. Now, if the Article 23 has some sense because of fundamental right, impliedly everyone the country has a right not to be trafficked. So the trafficking is a fundamental, anti-slavery is a fundamental right. Everyone has a right not to be trafficked. When anyone, even a single person is trafficked, and state failed in due diligence, then the state responsibility automatically comes. The state has to take measures, preventive measures for conducting for combating trafficking. How we will do it? How the state is doing? So now we have to see whether this trafficking is really what Article 23 has emphasized, where we stand today. So we have seen from the Constituent Assembly the mandate of the anti-slavery legislations in 23. And the idea was that once this legislation comes into existence, most of the practice of the slavery will be taken care of by domestic legislations and they can be wiped out soon. Now soon means we are already 70 years independence. Constitution from long time we are already there. Where we stand. Now just let me give you an idea what we have done to achieve this. So in order to enlarge this Article 23 or 24. So what we have in Constitutions, Article 23, we have other articles also, 24 is also there, Article 8 with Article 21, and we have many cases where they quote one after another talking about anti-slavery thing. The recent most important case was Bachpan Bachao Andolan versus state, where Supreme Court mandate for rescue of all children who are in circus industries, exploitation industries, and they will be rescued. Where we stand today? What the government has done to achieve Article 23 mandate. Now, when we use the word trafficking, trafficking could be for many purposes, and definitely each trafficking mandate for their abolitions is a mandate under Article 23 of the Constitution. What could be the purpose of trafficking? And let's see one by one. One of the purpose of the trafficking could be labor. So labor trafficking. For labor trafficking, what the laws we have in the India? Which law talk about combating labor trafficking? Bonded Labor Act we have. When we see Bonded Labor Act, excellent legislations, but then consistently we are in a state of denial. So cases like Bandhwa Mukti Morcha or other cases where court gives one by one directions. Professor Upendra Bakshi versus the state with the conditions of the homes where the people live, including the latest case of Bachchan Bachao Andolan. We are in a state of denial. There are several occasions when the states submit their report to the Supreme Court. They come with the mandate that we don't have any bonded labor in the country. Bonded Labor Act, definitely powerful legislation, states cognizable offenses, actions can be taken. DM has a power for providing compensation, very powerful act. When we see implementation, LCRB data, how many bonded labor cases are rescued, how many cases we started every year, is only minuscule. When we see the total number of offences of bonded labor throughout the country, anywhere in the country, brick film, other things, people from Jharkhand, other places, the laborers are brought. Nirasi Chaudhary case and other cases where the categorically Supreme Court says that if any laborer are not given the minimum wages, they are all exploitative labor practices and accordingly they fall within the purview of the bonded labor. But the number of implementation, how much we have achieved, is minuscule. For labor, child labor, we had legislation, we have legislations. Why I said had and have? What law we have for child labor? We have child labor regulations and provisions and for a long time, and there's an amendment recently brought in. Before this amendment, while to show the outside world, the government brought the law of child labor. But was government having power or police is having power to prosecute the offender under the Child Labor Act before amendment? Anyone has idea among students? Was it cognizable offence? Child Labor Act? It was not. So what happened in many occasions, and that's the beauty of the law when we see the legislations. It is not the law in place, but what mechanisms we have developed to implement that laws. Are we making sufficient enforcement mechanisms, or we created some hurdle in implementation? The Child Labor Act, till long time, it was non-cognizable offence. Impliedly, if someone has to start the prosecution, what they have to do, either the labor inspector will go to the court and file a complaint petition, or any citizen can go to the court and file a complaint because it's non-cognizable. We expect that all other cases, police can start investigations, prosecute the offender, but these kinds of cases comes, the law does not want to give power to the police. And then recent amendment they make it cognizable offences. So there are many law when come into existence. We create some hurdle in such a way that the law will not be implemented because many occasions it is non-cognizable offences. Who will take actions? And it has shown adverse impact. For instance, let me share one example of child labor, where it's again mentioned under Article 24 of the Constitution. A girl child who was working as a domestic help in Calcutta, in an area, she was beaten by the employer to the extent that like there's a burn mark in her body. She was thrown out of the home, she was crying. Some NGOs intercepted immediately, took her to the hospital, then went to the police station, registered an FIR. FIR was registered only under the IPC provisions, 324 IPC. While there could be other sections, but they use only 324 IPC. We have that time Juvenile Justice Act, earlier act, before 2015. In earlier act, there are sections in the JJ Act was section 23, which says that are general sections, any kinds of cruelty to the child, 23 Act tracks. Now in that case, what other law could have been used? Child Labor Act could have been used. Police has prosecuted only under the IPC 324. NGOs involved, so much investment, NGO went see what undergoing treatment in the hospital. 164 was done. The employer always they powerful people, so they filed a requisition against the injury case and take leaves in the High Court. In any case, later on, police submitted charge sheet on 324 IPC. The employer come to a lawyer like you, and as a lawyer, what advice will you give to the client? Case is not under the JJ Act, case is not under the Child Labour Act, case is under only 324 IPC. What will be your first advice as a lawyer? A client has come to you. You have to serve the interest of your client. What advice you will give? You will first find in the CRPC whether this T24 is cognizable or not, compoundable or not. If it is compoundable, then you ask your client, okay, why do you settle it? Just talk to their family, pay some money and settle it. That's what's happening. So the charge sheet was submitted, when the hearing was in court, both the side that because of laborer, normally they work in connivance with the family member has sent only the laborer. They both submitted, went to the court, submitted a compounding petitions cases ended. Now this entire effort of police agencies, effort of your NGOs, effort of other functionaries all become zero because the employer immediately was the impact of the compounding acquittal. So any offence is compounded, 320 CRPC says is amounted to, if it is before framing the charge, discharge, after framing the charge, acquittal, case relating to acquittal. Had they used JJ Act or Child Labour Act, could case be result compounded? Can the case be compounded? Answer is no, because neither JJ Act nor Child Labour Acts are compounding the offence. These are the all technicality. We have law, but how laws are interpreted, how the laws are used to in one context, in one way, other context differently. So it's not only important whether the really laws are used, whether they have used the right sections, right provision of the law. So we have a Child Labour Act, we have Bonded Labour Act, but still we lack in implementations. Because still is not a priority offence for the state agencies. So Article 23 of the Constitution says abolition of trafficking, but trafficking for labour is rampant. Trafficking of bonded labour is also there, and other experts are also there. Now let me come to other category of trafficking. So one, trafficking could be for labour. What could be other ways for trafficking for other purposes? One is major is sex trafficking. So trafficking for prostitution. Now again, in trafficking for prostitution, we have an act. What is the act name? For combating sex trafficking, or we have ITPA. Isn't it? What is the full form of ITPA? Immoral trafficking with insurance trafficking. ITPA. Initially it was PETA, SITA, then ITPA. So present name stand as ITPA, immoral trafficking with insurance. Now in ITPA, if you see the statistics under the ACRB data, the number of cases in ITPA is very small. It's not much. Facts remain that a huge number of trafficking exists throughout the country. We all know this when this act POXO came. What was the background? What happened before POXO? Delhi rape case. What was the case? Nirbhaya. So Nirbhaya case, everyone's conscience was so much adversely affected with demonstrations, everything we did. And ultimately there was a committee, Verma committee. Verma committee suggested for some new legislations, and we come up with the new legislations. How many of you have seen the documentary made by the BBC on the Nirbhaya case? Its name is India's Daughter. That's a documentary they have made. Anyone has seen that documentary? You have seen it. Okay. The documentary the day it was supposed to be telecast in India, it was banned by the government of India because they don't wanted to show it, bring it to life. But it is there in their UK website, so anyone can see. Internet has provided that facility to us. Now, why I am using this case and linking this with the trafficking? There is another dark side of the impact case which has not talked about. The other, we all know that the impact case happened. We all know demonstration happened. We all know law Burma Committee report was suggested, and we got the new legislation. We got section 370 of IPC, on which we will talk little later. But what we don't know is that these two all the accused persons, all the friends, where they were going that day. And how can these girls become victims? Now that's the answer will be given by your documentary. If you see the documentary, because this facts is not in public domain. The documentary, while giving an interview, the accused says that it was Sunday. So Sunday is basically a enjoyment day, freedom, weekend, they want to enjoy. And for where they want to enjoy. So they took bath, got ready, they consumed alcohol, they were going by bus. It's for the purpose of enjoyment. Anyone has an idea where they were going? They were going to GB Road in Delhi. GB Road is biggest red light area in Delhi. So they were going, in my views, they were going with a mindset that sex is there for purchase. They wanted to purchase sex in the red light area. On the way, they found some helpless girl, Nirbhaya. They exploited her, and they whatever the things we all know what happened to her, unfortunate things happened to her. Now they were going, so they are habituated to. And they have a mindset, it's a culture which has been developed where one sex, this thing can consider as this is for the commercial transaction. So they were going to GB Road for a purchase sex. They exploited a girl and they killed the girl on the way. Now, what has not been talked about after the Nirbhaya case was, now this factory or industry which exists throughout the country, where exploitation is going on, where trafficking is rampant, girls are trafficked, kept in those areas for the purpose of enjoyment and exploitation by the others, whether it's a paid or free, different questions altogether. But it's a culture where the people, a man can consider that the women are there for purchasing, or sex is there for purchase. This culture nobody talks about. And we have not found out anything in Burma report which can suggest that okay, how to counter this culture. I know had might be there is no GB road, it might not have been human being there. Had we done something of this, whether we have acted upon it. So when we say, when we brought the legislations, the concept of trafficking or the modern day slavery which exists, and this entire industry, that we say sex trafficking, which exists throughout the country, whether that we have done anything to address this sex trafficking, whether we have done anything to change this culture, the culture which is responsible for one after another exploitation of the girl. And there will, if we talk about, because the sex trafficking is an area where my research area, I've done my doctoral work on sex trafficking research, and my work is recently published by Conference Center in a book form. So you can find some 80 cases which I have analyzed. You can find in the book all the cases which I surveyed. So we can discuss some of the cases with you also on the sex trafficking. Let me look into the law what is there. So we know the sex trafficking is rampant. This trafficking exists throughout the country. No state can say I am immune from the sex trafficking. On contrary, we have Article 23. Article 23 that everyone has a right not to be trafficked. Now, both the things, how it can coexist? How can the industry exist while the article says you have the right not to be trafficked? So we want to keep the entire industry alive while Article 23 is alive in the constitutions. We have not taken any concerted effort. What effort we can do? On contrary, what we have not done, let me deliberate upon some specific point when I say that many occasions, while there is a law themselves create an infrastructure by which the law will not be implemented. Now why I am saying this? I said you in the Child Labour Act, non-cognizable according not being implemented or less implementation. Under the ITPA, in section 13, I am not talking about the offense, I am talking about the procedural part. In section 13 of ITPA, it says that the cases under ITPA shall be investigated by a special police officer. Now, who will be special police officer? The Act says special police officer not below the rank of inspector. Some state passed the law where it says that DSP can be special officer, police officer. Some state passed the law which says inspector can be special police officer. Believe me, in any legislations, as soon as they talk about these special mechanisms, on the background they ensure that it will not be implemented. The reason is that the special police officer what we are talking about, they are once someone becomes inspector or DSP after serving 10 years, 12 years, 15 years, some inspector or investigator. Superior officer does not want to take that much burden to again go back and act like investigator. They are become superior now. They want to guide but don't act themselves. So for all practical purposes, the places where inspector is not there, those who are from some any not major cities, just outside the cities, police station, who is heading the police station? If still in remote area is sub-inspector. There are many police stations in the country where the officer in charge of the police station is sub-inspector. That means in that police station you don't have even a single person who can investigate the case under the ITPA. Even in those places where there is an inspector, I don't know, officer in charge. So you might have a 8 sub-inspector, 1 inspector. Now, superior officer does not want to take burden on themselves and they always try to avoid. It's a human psychology. We all try to avoid the work. So what they do? Okay, book under IPC. That's the reason that I found from my case studies that almost 65% cases, 64% cases of sex trafficking where the clear sex trafficking has been taken place, the police prosecuted the offender under IPC. When they prosecute the offender IPC, that means they are ensuring that the sub-inspector who are the lowest rank officers in the police for investigating purposes, they will investigate. Now there is nothing wrong in doing something under IPC. Difficulty arises that the kinds of presumption or kinds of strength which is there under the ITPA, we will never get under the IPC. And let me share one case example which I found during my research work. A girl was rescued from the brothel in Calcutta. NGO was involved. Her 164 was done, medical examination done, minor girl, everything is fine. Police accused persons are arrested, both are arrested. They were under trial prisoner. So no bail was granted because of the seriousness of the case. What the police did, police registered the case under for kidnapping under IPC selling and buying under IPC 372, 373 of the 370 buying, selling under 372 of IPC. So they registered a case under the IPC. They had not used ITP. There were evidences. Now, in the time when the girl rescued and when the trial start, we always have a gap. The gap could be 2 years, gap could be 3 years, gap could be 4 years, depending on the workload of the police and other department. After that, girl is not found. So the major witness is unavailable. There 164 statement is there. There are ample evidence during the trial. The place from where the girl was rescued, it was a brothel. There is ample evidence to show that the customer used to frequenting there. Now these evidence comes, but the girl herself has not come to the court. Her mother was not there in the court. Under trial prisoners, they were in jail for all the period. In one day, court conducted 313 etc. and then acquitted both of them. Why? Because the case was there for kidnapping. For kidnapping, you require one kind of ingredients. Kidnapping is that minor has been taken away from the custody of the guardian. So guardian evidence becomes necessary. Evidence was there for selling or buying. For selling and buying under 372 or 373 of IPC, you require some kinds of a transaction, find some transactions to prove. Had police used section 3 of ITPA for running the brothel, 4 of ITPA for living on the earning of prostitution, 5 of ITPA recruitment, 6 of ITPA keeping someone in the brothel for prostitutions, at least section 3 or section 4, whatever the evidence was there on the record, the case could have been convicted. Those people who are under trial because should not have been acquitted. So even though we have a law, ITPA is there, but how effective this ITPA legislation is, how much cases are really there, how much effectiveness are there, what provisions have been brought in under the ITPA to address this kind of cases. So one is, if the law is there, we don't implement that because there is a procedural hurdles are there in between the process. So labor trafficking we have seen non-implemented. Sex trafficking again there are procedural hurdles which make it difficult to implement. So we have millions and millions people are trafficked. Any idea how many people throughout the world are trafficked? For a long time, in the year 2009 and 12, the ILO, International Labour Organization, has done research work where they says 12.6 million people were trafficked. So trafficking in persons report adopted ILO report, and so if you see the 2012 almost all the reports, they all uses 16.8 million people are 12.6 million people are trafficked. Then subsequent some of the other research says 23 million people are trafficked. So 2014-15 onwards when we issued the ILO report, they say 23 million. When this slavery index comes, slavery index followed their own methodology and they suggested that 33 million people are trafficked. India, in one of the report in 2015 or 16th report, they say that we are number 4 in terms of number of slaves. So the thing which we should not be proud of. We are number 4th in one report, other report says 5th or 6th, where we are in terms of number of slaves. So when an international report says we stand in 4th or 6th, and so many people, million people are trafficked, even if we see that okay, there may be by methodology, they might find half of their mistake. Even if the half of the number is too much beyond our imagination. So many people are slaves in the country. So conflict is, while we have Article 23 which says no one can be slave, no one can be trafficked. In practice we stand 4th or 6th in terms of number of slaves in the world. So every corner of the countries there are slavery in some form or other which are there. Sex trafficking we say, so RTPA, ITPA is there, but ITPA implementation is completely lacking, is not there, it's not being implemented properly, because one of the hurdle is section 13 of ITPA, which says senior police officers, to manpower or some kinds of the money which is involved in the trafficking. Siddharth Khera in his research work is more than 300 billion dollar etc. is being transacted. So his work he talks about the number of traffic. I don't go into statistics, I don't know exact figures, and all these figures are assumptions. But whatever the assumptions are, if a fraction of it is true, it is a huge industry, huge money. Because the money involved, many occasions the enforcement become difficult. They don't able to enforce. Let me share one or two examples to you. Now in IPC, there are two sections are there, 372 and 373. 372 says selling for the purpose of prostitution. 373 says buying for the purpose of prostitution. As a common sense, if suppose there is 100 cases of selling, how many cases of buying should be? 100. Anyone can see this NCRB data. NCRB data is data which reflect the number of FIR registered. NCRB data is based on the FIR which is registered by different police stations throughout the country. If you see NCRB data, then these are the challenges. We have a law one thing, but the implementation is completely different. If you see NCRB data of 372 and 373, you will astonize, you will see that some year the cases under 373 number is 372, 112, selling is 112, buying is 6, selling is 103, buying is 8 or 9. So not every fraction of the number of cases registered for selling is registered for buying. What could be the reason? With a common sense, if there is a seller, there is a buyer. If someone sold a girl, there is definitely someone who purchased the girl, bought the girl. So a human being becomes subject to sale and purchase like any other commodity, which again against Article 23 of the Constitution. Can anyone have an idea what could be the reason? Why it is so different between the selling and buying? What my perception is, and I found in some cases, the persons who go to sell a girl in a brothel, in a market, they come from outside, reaches the brothel, some interventions taken place, the girl is rescued, so police has to register an FIR. For police, registering FIR for against the outsider might be easier than the registering FIR against the local brothel owner. And that creates difference when you see the NCRB data. My perception is that while there is so many number of cases, that's an infraction, 112, 113 in a year, is a very small number. Because of millions of people are trafficked. Thousands and thousands of girls are saved in every month in some railway areas. So this 110, 112 throughout the country is a very fraction of it. But even in this fraction of number, the difference between the number for selling and the buying is again a huge gap. And that's the reason my perception is, it's because the industry which generates the money. So how to combat this trafficking, particularly sex trafficking? My understanding is, if we have to combat any trafficking 23, but the law is that ITP is not enough, we require something more. What we require more? Two things. One is, this industry is surviving. So industry of exploitation of a girl is surviving because there are two category of people who create demand. One category of persons are customers. Second category of persons are profiteers. So customers generate a particular kinds of girls demand that lead to the profiteers who bring the girls for the services of the customers. So this, unless we target this both of them together, we are not able to combat the trafficking. Implicitly, my view is that for any combating sex trafficking, we must brought the law to penalize the purchase of sex. So the customers must be prosecuted. And there are many countries in the world where they have brought these kinds of legislations. Second thing, but this alone is not enough. Parallelly, the girls are trafficked in sex trafficking cases because they are vulnerable. It is utter nonsense if someone says because of poverty someone trafficked. I didn't find a single case where only because of poverty someone trafficked. Because of poverty someone become vulnerable. And that vulnerability lead to trafficking. Because of illiteracy someone become vulnerable. That vulnerability lead to trafficking. And that trafficking lead to prostitution. So there could be many reasons. Because of lack of economic independence, I found many cases where diverse ways the peoples are, particularly in sex trafficking. One girl who was trafficked in Bangladesh, not so very poor family girl. She was sometimes again the culture in the society made the girls more vulnerable. So in her case, the culture of bigamy in a Bangladesh society. So her father was the postman, so government job, getting reasonable salary. Her father did second marriage. This girl cannot cope up with her stepmothers. She left the home. There are some facts. She left the home, went to Dhaka, started working there. A boy tried to become friendship with her. She refused to become friend of her. That boy's sister became friend with this girl. One day took her to home and she was with the plea that the girl is ill. So there's a circumstances, drama was there, and by which the girl was brought to home. That same boy, some intoxicating things had been given to her, and thereafter she was half conscious kinds of situations. He commit rape of the girls, make videograph of it. After 3-4 hours, when she get little conscious, having some energy to come, she was going. The boy said, "Where you go? This is the video. If you go, I will upload." Now you have Facebook, YouTube. We don't know who will traffic which point of time, in what manner. Thereafter, she was crying furiously, and then thereafter the boy says, "Okay, look, I propose you for love. I wanted to marry you. You have refused, so I already did these things just to marry you." Girl said, "Okay, if you want to marry me now." The girl started living with her rapist. There was no marriage at that time. The boy exploited her for another 15-20 days of one time, and the same boy forced us into prostitution in Dhaka. After 5-6 months, brought her to India. As like a property we give on lease or rent, she was rented out for 11 months from one owner to another owner. And on 4th lease, when she is supposed to be leased out for another 11 months, she created some kinds of scenes in Goa. She was rescued and then she was repatriated to Bangladesh. I took her interview when she was in Bangladesh. All these things over, and then I took her interviews with all the record. Now, so when we see that only the victims which are from a particular background or poor family, they are only trapped, that's not the notion. We don't know who can be trapped in which manner. We don't know whose boyfriend will do something, and then by that they will blackmail and force the girls to do something wrong. So apparently all these things which will look like a escort service, etc., it look like a voluntarily choice agency. Unless we go into in-depth on it, we will not understand the reality what is there. And my own understanding is that any quantitative study is not enough to understand the reality. That's why I say that I didn't find a single case where some girl was trafficked only because of poverty. There is something more. It's all because of their vulnerability. So in order to combat trafficking, particularly sex trafficking, what we need is, one side we need to address both the demand of customers, demand of profiteers. For profiteers we have provision in ITPA. So in ITPA we have section 3, section 4, section 5. For profit for the customers, we don't have any provisions. We have added in IPC. We will go into IPC. We will see the IPC provisions soon. So we have so the conflict is, we have Article 23, Article 24 for labor, but the reality is completely different. So even after 70 or more of independence, we have not come to a situations where we able to fulfill our fundamental right of not to be trafficked, not to be enslaved. The slavery is persist throughout the country, every corner of the country. Okay, even if these are situations, then how much it is a priority offense? Is it in our priority? Is government really concerned about it? Is our functionaries, we get excellent judgment. We have multiple cases from the Supreme Court where the court has given one after another excellent decision, but that's sporadic, sometimes comes. Unless we have a structure or institutional check, we cannot able to change the situations. So what we require, and why it's not priority offense? Why not the priority for this kind of slavery? All of you probably you have seen there was a constitutional review committee by Justice M. N. Venkatachalaya. Justice M. N. Venkatachalaya committee has reviewed the working of the constitution. So how the constitution has performed in 5 decades. And it's a very voluminous report. So if you see, they have a part 1, part 2, part 3, around 7 or 8 volumes are there, very voluminous report, which has extensively discussed about the different part of the constitution, how is being worked in last 50 years. But there is no discussion on 23. So there is a discussion on fundamental rights. So Article 21 has been discussed. Some aspects of the labor law, etc., have been discussed. But per se to slavery exists, which require an attraction. We are falling in terms of the numbers when we say, some reports say some years that we are 4th or 5th or 6th in terms of number of slaves, but still it does not catch the attractions of the policy maker when they working on the question. And we see the 23 for which implementing what are the domestic legislations are there, that legislation how to improve upon, we still have not found the real pictures. Now we come to other circumstances, and that basically last part of the thing which I want to discuss with you is when this Nirbhaya case happened. Post Nirbhaya case, we all know Verma committee report. This Verma constituted the committee has submitted the report. I said to you that for combating trafficking, what we require is 2 action. One side we have to address this demand, it's a profiteer's demand and customer demand. Other side we need to remove or act properly, positively to reduce the vulnerability. So vulnerability play most important role in trafficking of a victim. When this is trafficking taking place, the Burma Committee report has rightly pointed out that we don't have any single legislations which can define trafficking and which created an institutional structure for combating trafficking. So they suggested that we must brought in domestic law for trafficking. And what would be domestic law? They suggested to adopt. There's a traffic, I said in the beginning, in the year 2000s, there's an international conventions came into existence on organized crime. One of the protocol of the convention was protocol to combat trafficking. For trafficking, we call Palermo protocol, trafficking protocol. That trafficking protocol, first time in Article 3, they defined human trafficking. And defining human trafficking, they have done, there are three components. And we call act means purpose. Article 3 of trafficking protocol, this says, if anyone transport, transfer, recruit, harbor, receive. So anyone transport someone, harbor someone, receive someone, travel. So these are all called action. Means of, by means of force, coercion, abductions, fraud, deceptions, abuse of power. Now all these are there in section 370. There is one more thing was there in the Article 3 of ITP in trafficking protocol. Abuse of power and abuse of position of vulnerability. When we see Article 3 of trafficking protocol, in the means column, when they identify different means which have been used by the traffickers, abduction, fraud, deceptions, etc., abuse of power, and last one was abuse of possession of vulnerability. This is most significant means. So because in every trafficking a person is trafficked because they were vulnerable and their vulnerability is misused by someone, then only they become trafficked. But when section 370 came into existence, section 370, while defining this entire trafficking in section 370 and penalizing it, they verbatim copy the entire Article 3 of trafficking protocol, except only one part, which is abuse of possession of vulnerability is missing. They have not included in Article 3, section 370 of IPC. Now there is no justification whatsoever why, when 94% of the words of Article 3 has been incorporated in section 370 of the IPC, only 4 word violation is excluded. The select committee one of the justification was that abuse of position of vulnerability, this vulnerability word is too broad and too vague to interpret. That was the argument. But then we have different legislations in India which has used the same interpretation, same language. For instance, in a state legislation, Goa have a different Children Act. Much before this 2000 Act came into existence, the Goa had their own Goa Children Act. In Goa Children Act, they have defined child trafficking. And when they define child trafficking, they include abuse of position of vulnerability as a means of trafficking. So what we see is, even when we brought section 370 of IPC to implement or combat trafficking, it is still ill-conceived. Because every trafficking, when it is taking place, the trafficking taking place because the girls or boys or anyone who traffic, whether it's a trafficking for organ, trafficking for labor, trafficking for prostitutions, all these trafficking taking place because they were vulnerable. So vulnerability is the only point for which they are being trafficked. So that's again is ill-conceived provisions and it's unhappy. More about the thing was that in order to implement trafficking protocol, UNODC has developed numerous materials. So when the argument comes that a vulnerability we cannot define, the UNODC guidelines and their draft act has given a broad definition of vulnerability. So it's not that we don't have enough material or enough guiding principles by which we can implement this vulnerability thing. It was there, but somehow the legislature has not taken into account that. Now with 370, we got 370A also for the demand side, where the customers can be prosecuted if someone uses the service of the thing. That's again a very positive sign which is there, but implementation is lacking. So while 370, 370A, both the sections are quite welcome, you should welcome it. Still there is a gap in section 370, and 370A has not been implemented because we rarely find cases where the persons are prosecuted under section 370A. Remember, for customer demand, when I am saying one of the arguments which always comes from the on the sex trafficking particularly, there is always a lobby in the world. There is an entire world, academicians, feminists, they are divided into two groups when we say sex trafficking. What are those two groups? There is a one group of the people who believe that the prostitution is work. They should give sex work should be recognized as a work. A lady who is in prostitution is carrying an agency. Even if the work is not a good work, we must respect their agency and we should allow them. Why the state should interfere? It's amounted to moral policing. So one group of the people in the world who believe in the sex work model, and they consistently arguing for legalization of it. Which are the people involved there? If you try to know, or if someone wanted to work on this area, at international level there is an organization which is called which is a parental body for all these groups who are for pro-legalizations, and we called GATW. This organization is called General Alliance Against Trafficking of Women. Both the groups use the word trafficking. General Alliance Against Trafficking of Women. This intergovernmental organization head office is in nearby countries in Bangkok. There is another NGO, international INGOs, international organizations, which call it CATW, Coalition Against Trafficking of Women. All the NGOs are activists. So second lobby, the second group who feel that prostitution is exploitation. No woman in the world by choice they choose to be in prostitution. They believe that had we in a society, had we have equality, in equal situation, no woman will choose to be in prostitution. So even if someone go there, it is absence of choice and it's a force on them because they believe it's exploitation. So therefore the second lobby and the headed by Catherine McKinnon, it's exploitation. So organizations at internationally which work for this is we call CATW, Coalition Against Trafficking of Women. I am not saying my view. You completely you have to make up your own independent views. What you feel, what you believe. But there are people. It's not starting from the classroom. Might be in your classroom. Someone will argue in favor of a work model. Someone will argue in favor of exploitations. Starting from here to world over, people are divided into two groups. One group believe it's a work, and when you see their writing or articles, they always use the word sex worker. There's another scholar if you see their articles or their book, they will always use the word either prostituted women, women in prostitution. So by reading this word, you will find which lobby they are. So their ideological views, and there's an entire world over, they are divided into these two categories. For us, because Article 23 mandated trafficking in women, this mandated things, questions of sex work model does not arise legally. We require to combat it. In fact, when we signed 1949 conventions, and on the basis of which we have ITP, Human Trafficking Prevention Act, the preamble of that convention itself says that prostitution is incompatible with the human rights of a woman. Second thing, India is party to SAR conventions. The preamble of the SAR conventions also says the prostitution is incompatible with the human rights and worth of a woman. Impliedly, considering 1949 conventions and the SAR conventions, our legal obligations, legally we cannot think of the sex work model. I personally, my view is that it is not work, it's exploitations. And my own work, when I've seen, I interviewed in my research, doctoral research, I studied 80 cases. But before that also I interacted with many people throughout the countries. And I never found a single girl or any woman who are there, they say they enter into prostitution voluntarily. I found very pathetic cases. I can share hundreds and hundreds of cases, the way the persons are trafficked and forced into prostitutions. In my work, I refer to the classification of the classes of women. So, when we see these two kinds of lobby in sex trafficking, one lobby who argue for the sex work, if you see their website of the organization NGOs which work on the, who believe in sex work. So in India, for instance, there is an NGO called Durbar Mahila Samiti, DMSC. They are proponent of sex work model. If you see their website, you will find some story where they talk about the girls when they come and then they started their in prostitution voluntarily. While there are NGOs like Shakti Bahini, Delhi, Apne Aap Women Worldwide, Calcutta, Sanla in Calcutta. So there are many, Prajwala in Hyderabad. So there are many big organizations which does not believe in sex work model. They believe in sexual exploitation model. And you will find their case study. From case study you will find what they wanted to argue. But when you, even if you go in depth, in the cases which refer to all the NGOs we talk about sex work, you will find there are exploitations in the beginning. So what's happening? Why they talking about the agency or rights? They talking about the agency or rights because there is a classification, and classification comes in this sexual sex slave industries. When some girl is forced into prostitution at the early age, maybe 13, 14, 15, 16, and just think about a situation. Suppose in an area, GB Road, if suppose there are 20 girls, it's a minuscule number. There's 100 hundreds are there who are there in GB Road, below 18 years. Every sexual intercourse is a sexual assault, penetrating sexual assault under the POCSO, rape under the IPC. So if 20 girls, every day 10 customers, in one precision level, how many rapes? 200 rapes. If you calculate throughout the country, thousands and thousands of rapes every day. And these rapes are tolerated. We are, as a civil society, we are tolerating it. We are accommodating it. We are accepting it. We don't consider it exploitation. But this is going on everywhere throughout the countries. So when we say this, when you see this, the case studies there, I analyze and say there are four categories. When the girls enter into prostitutions or when they traffic by the others, initially they call it chokri young girls. They are pure slave. After 5, 7 or 10 years, they become adhya, so they get half of might be some income. After again another 5, 10 years, they become independent. Now the people who believe in sex work, they always show these girls who at the later stage might get some independence. But these girls get independence or women get independence after exploitation of 50-20 years time. That cannot become a justification for opening the door of exploitations of other young girls. If the industry will allow, I said in the beginning, if the industry is thriving, industry is alive, there are more and more women and girls will be forced into prostitution or trafficking in one form or other. So we require to address the demand side. Unless we address the demand side, we cannot get it. So these are the two categories we have discussed on the trafficking. So we have a labor trafficking, we have a sexual exploitation or sex trafficking, any other forms of trafficking, organ trafficking. That's another industry, huge number. We don't know whose organ when it will be taken. We don't know when we see the cases like Nityahari Khan in Delhi, nearby Delhi area where and the person is now run away. The children who are killed. One of the apprehension is that it might be organ trafficking. Some the news articles or other here and there, some informations which came, how much truthful is the only investigating agencies will say. This Baba Ram Rahim, when it was taken place, entire hospital kinds of arrangement was there in the ashram, and there are people who suspect this organ trafficking. We don't know. We are not sure. Investigating agency will talk about it. But millions of people are trafficked throughout the year. We have legislations. We have organ trafficking act. Its powers the state government to notify and implement it. So we have this for organ trafficking. We have a separate law. Labor trafficking, we have a separate law. For sex trafficking, we have IDPA. For generally, cumulatively, for everything, we have one section. We come in 370 of IPC. But still, the kinds of support system which are victims require, whether it's organ trafficking or labor trafficking or sex trafficking, the institutional infrastructures which they require, it is still missing there. And the special laws which are there, in most of the circumstances, the special laws are not implemented as they are supposed to be. IDPA is not implemented in many circumstances. Only the police do the IPC offences because again the procedural things. Organ trafficking cases again those are reported even it's not always implemented. Many of it are not being implemented. So we have just to when we see trafficking, Article 23 talk about trafficking. Again, before coming into existence of Article 23, when it's Article 17 of the Constituent Assembly draft article, that point of time from organ issue was not raised that point of time. But this concept like intergenerational prostitution, concept like Devdasi issue was raised in the Constituent Assembly. Whether we have get rid of it, are we able to abolish it? Answer is no. Still there are practices in many places part of the country where people are there are practices of Devdasi, where people are dedicating their daughters to the god, and ultimately they all become the slave. Sexual slavery is sometimes in the hands of the priests of that temple, sometimes of the villagers, later on the exploitation by the villagers, and this is rampant in many parts of the countries. So while we have provisions like Article 23 in the Constitution, which from the beginning look for anti-slavery mechanisms, which look for will not be slave, the reality seems completely different. We have slave throughout the countries. We have slave in different forms, be it sex slavery, slavery for labor, slavery in the form of Devdasi, or organ trafficking. So if we have to come back, we require not only the law, we definitely need much improved law, but also we require their effective implementation. If we can implement effectively, then only Article 23 will be successful. Otherwise, Article 23, as it remains mostly date later, remain date later, we have not able to get real ensure the abolition of slavery throughout the countries. And sometimes later on we can get some other report will say where we stand, like Global Slavery Index, which says sometimes 4th or 6th or 5th, and huge number of people who are trafficked, they are mentioned. Okay, these are a few things which in respect to Article 23 I wanted to discuss with you. We have few minutes. Any kinds of questions which you have, you can ask on these all four categories of slavery. We will discuss about trafficking, organ trafficking, labor trafficking, sex trafficking, etc. Yeah. So we are open to the questions if anything which you want to ask.